May I please the court? I'm Mark Stopa, counsel for the appellants. I would request 5 minutes for rebuttal. Your Honor, the issues I'd like to start with is what I believe is the absence of competent substantial evidence that the plaintiff mailed the default letter as required by paragraph 22. There are two ways that they take the position that they prove this issue. One is testimony about a routine practice of mailing the letter. The second was with a mailing log which purported to show the mailing of the letter. I submit that both of those were not competent substantial evidence because they both contained inadmissible hearsay and the witness lacked a predicate to testify. To me, the fact as I make that statement that really should jump out and that starts the whole argument is that the lender's witness acknowledged that third-party vendors were sometimes used for the mailing of these letters, and she did not know whether such a vendor was used in this instance or not. And that's made very clear on page 81 of the trial transcript. So as you go through the testimony, it's clear that the lender's witness didn't know if a vendor was used, didn't know the name of the vendor, had no documents showing the procedure of the vendors, and her knowledge, she acknowledged, was limited to her review of documents. And there were no documents showing the procedures of the vendor, no documents showing whether a vendor was used or Wells Fargo was used, no documents showing the name of a vendor. This individual was never employed by a vendor, had never spoken with the vendor, had never talked with a vendor on the phone, never set foot in their offices, nothing like that at all. Now, as I was going through this argument, the judge was agreeing at first that the witness lacked a predicate in order to testify about the procedures for mailing a letter under these circumstances. That was on pages 89 and 93. And what then transpired is that the lender's counsel essentially tried to lead the witness through a sequence of testimony where the witness would say, well, the procedures for the vendor were the same as those for the lender, and I'm there saying, well, what's the predicate for the witness to say that, especially when we don't even know who the vendor is. So repeated objections on hearsay and predicate on that.
The testimony was that Wells Fargo does some of its own letters, and sometimes third-party vendors do letters, but that in either instance, the letter doesn't appear in their records until it is documented as having been sent, correct?
Well,
Is that what the testimony is?
I think that's fair to say that was testified to, but I was objecting to that testimony on hearsay and predicate, and I submit that there was not a predicate for the witness to describe that procedure when she doesn't even know who the vendor is, and there was no documentation showing how that takes place.
But she testified that any vendor has to comply with the procedures that Wells Fargo established. She testifies as to her experience and longevity with Wells Fargo and her knowledge as to how Wells Fargo and vendors handle these things. Why is that not enough?
Well, Your Honor, when you wrote the decisions in Edmonds and Allen, you made clear that to testify about a routine business practice, you have to have of mailing letters, you have to have personal knowledge of the procedure. In both decisions, you distinguished the Hoskinson case from the 5th DCA, where in that decision, the lender's witness observed letters being delivered from the mailroom as an example of the personal knowledge necessary to testify about a routine procedure. Here, this witness's testimony is limited exclusively to what other people told her, other people within Wells Fargo told her about a procedure of a different company that she knows nothing about at all. How can she say that what this other company's procedures are with any personal knowledge when she doesn't know who it is, she's never talked to...
But she says she does know that the procedures required of third-party vendors must be basically the same as or identical to the procedures that Wells Fargo uses.
But how can you have, I respectfully submit, how could she have personal knowledge of that issue? Personal knowledge you see with your eyes, you observe the mail being delivered from the mailroom, you shadow that department or something like that. What she's describing there, she's describing what's either written in a document, such as the written policies and procedures of the vendor, or how Wells Fargo operates with the vendor in written policies and procedures, which weren't in court, in a sense hearsay, or she's describing what someone else told to her. For instance, the lenders love in this context to use the term training, and this happened in this case as well. She was trained about procedures. Well, training, there's no hearsay exception to training. Training in this context means what someone else told you. That's not, you don't have personal knowledge because someone else tells you something. You have personal knowledge because you personally participate in it. For instance, the observing the mailing of letters like in Hoskinson, which to me is, I've always believed is the operative distinction, and Your Honor agreed with that in writing those two decisions. So I don't see how in a situation like this where the witness is simply getting on the stand and trying to say what a procedure is for a company, she doesn't even know who it is. She's never talked to them, never set foot in their offices, doesn't have any written documents, never read any documents that shows the policies and procedures of them. So I don't see how there's a predicate for her to say, yeah, the procedures are the same. The vendors work the same way. What's the basis to say that? Someone in Wells Fargo told me that the procedures are the same so that I could come testify to that in foreclosure cases? I mean, that's not personal knowledge. And I submit any case on hearsay and personal knowledge in any context in the law will show that is not personal knowledge. And so I get that there might be a concern or hesitance to create a standard that makes it impossible for a lender to show that a letter was mailed. Okay, I get that concern may exist. But I submit that you can write a decision that is consistent with rules of evidence that still takes that concern into account in a way that they're simpatico. You can do that consistently. And for instance, in a situation like this, where is the written policies and procedures between the vendor or the witness? Or even if you don't want to require that, it should at least be somebody who I personally observed that activity. I shadowed for a week, and I went into that department, and I saw letters being delivered. Something like that. It has to be something more than...
Who is the burden on to show lack of trustworthiness? You're arguing lack of trustworthiness, correct?
Well, that's part of it.
They're arguing a business record exception to the hearsay.
I'm arguing, right, that's part of it. In terms of the mailing log, I'm arguing, when the witness says this is made at or near the time of the event in the mailing log, and I'm there objecting on predicate, it's not just the trustworthiness requirement of the business records exception, which is their burden. It's also what is the witness's predicate to answer.
Well, it says unless the source shows lack of trustworthiness.
Sure.
So they're not going to go up and say, oh, this is not trustworthy. Their argument is it's trustworthy. We rely on this all the time.
And what I submit to Your Honors, there are two different issues subsumed within that. The first is the trustworthiness exception, which you're getting to. And the second is, what's the witness's basis to even parrot a yes answer to the made at or near the time of the event by a person with knowledge? There has to be a predicate in order to give that testimony.
It's kept in the course of a regularly conducted business activity. And it was a regular practice at business activity to make such memorandum, report, record, etc.
I respectfully submit that's not the predicate. That's what's necessary for the document to fall within the business records exception. The predicate is what is the witness's basis to answer that it is created near the time of the event. For instance, with respect to the mailing log, here you have a mailing log that the testimony established that the mailing log the entry was created by a Wells Fargo employee. Only Wells Fargo employees can create the entries in the mailing log. But then the question becomes, well, what is that information based on? Where is it derived from? Here the witness doesn't even know if the entry is based on information communicated from a vendor in some fashion or from a Wells Fargo employee. And so how can you parrot a yes answer to that is made at or near the time of the event by a person with knowledge when, for all the witness knows, the information showing the mailing of the letter is derived from a vendor, and there's some communication from the vendor to Wells Fargo that precipitates the creation of that entry? the witness admittedly didn't know. And so if there were a communication from a vendor to Wells Fargo, then that's the business record to the extent one exists. That was not introduced into evidence. The mailing log is simply a recreation of that, and that is not a business record, and the witness does not have a basis to say that was created near the time of the event.
Okay, so was that the specific objection at trial?
Absolutely.
And the judge had to decide a disputed question of fact on those issues?
Well, there was a disputed issue of fact because my clients testified the letter wasn't received, but that's not what I'm appealing on. What I'm appealing on is that there was no competent substantial evidence to even give the testimony. And unfortunately, in my view, this happens a lot in these cases where it's really easy for a witness to get on the stand and parrot yes answers to the prongs to the business records exception. I have yet to try a case where they don't answer yes to that question, right? And to me...
Well, that's why they're called as a witness.
Well, but you can't be a witness and be testifying without personal knowledge and a predicate to so testify. And for instance, I thought it was pretty telling here that this witness, after parroting yes answers to the business records exception, it's only on voir dire that the concept of a vendor even comes up. Only because I probe into the issue well, sometimes there's vendors in these cases, right? So they love to get on the stand and say, well, this is a business record by just answering yes to the 4 prongs without actually...
Her testimony, if I recall correctly, was that there was no indication that there was a vendor involved in this. You brought up the issue, do vendors sometimes do these? Does Wells Fargo use vendors? And she said yes. And I'm not certain that she ever conceded that a vendor, in fact, was involved in this situation.
Well, she didn't know. That's the point on page 81. Isn't it true that Wells Fargo used third-party vendors for the sending of such letters as of March of 2011? Answer, in some cases. And then we had detailed testimony and arguments went on for pages about how she didn't know if a vendor was used in this case, and there was no documentation showing whether a vendor is used in this case. And that's precisely the point. How can you say that a document is created at or near the time of the event by a person with knowledge?
If her testimony, which my belief is, or recollection is, her testimony was the documents to which she was referring and on which she and the bank were relying are consistent with the procedures that they require, and that each of the records that she has reflects the sending of the letter, including unique identification numbers that go with the letter and are put in the system when the letter is printed and issued. And then I understand you cross-examined to raise some question as to, in fact, did the bank send this or a third-party vendor, but doesn't that then go to appropriate inferences that a court may make and credibility determinations?
Judge, Your Honor, I submit not. And I think that the key, as I listened to Your Honor's question, I wrote it down, consistent with
you wrote really quickly because that was a lot of words in a short time.
What I wrote was consistent with the procedures they require. I thought that was the key phrase in your question, because what you're asking there is what you're assuming there is that she has a basis in order to testify about the procedures that as between Wells Fargo and the vendor. What is her and Your Honor required personal knowledge of the routine business practice.
Was that probed on cross?
Thoroughly.
In other words, if she says it met that standard and it goes on challenge, then it met that standard, even though there was some fertile territory it could have been probed, but it wasn't.
Well, there were numerous repeated contemporaneous objections. And
other than the objection, I mean, she said, this is my conclusion, and then that's my review, and it meets the standard. And now you're saying, well, it doesn't meet the standard, because how could it? You don't have any personal knowledge of what some third-party vendor may have done or not done.
I think the key is the personal knowledge issue. She doesn't have personal knowledge of the procedures of the vendor.
Let me ask a question that maybe ties this all together, at least as far as the procedures. If, in fact, the letter was sent by the lender, is her testimony adequate to establish the business records exception to allow the documents into evidence?
If it had been sent by the lender and there was documentation it was sent by the lender as opposed to a vendor, then yes.
Okay, so if the evidence were that it was sent by Wells Fargo, then her testimony was adequate as a business records custodian.
I think that is I think that's fair to say, although I didn't really think
Well,
of it
let
in
me
those
just-
terms, because you're speculating to even ask that question,
Well,
which is the point.
although there's also speculation on the appellant side that a third-party vendor was involved in this situation.
No.
And there could have been discovery and potentially impeachment to establish that a third-party vendor was used.
But it's not my burden to make the evidence admissible. It's their burden to make the evidence admissible. It's their burden to present a witness who can give competent testimony as to the routine business practice of mailing letters.
Mr. Stopa, you're at your 15-minute mark if you want to reserve your 5, or you can use it as you wish.
I do want to briefly touch on the doc stamp issue as well. There was no payment of documentary stamp taxes on this modification, and I submit that the dispositive answer in the law on this is set forth in the second of the last paragraph in 201.09 sub 1. The second of the last sentence there requires a renewal note that they pay the balance, that they pay the difference in the principal increase, documentary stamp taxes on that. It doesn't have to be pled under the SOMA case. It's not an affirmative defense, and it gives rise to a dismissal at this stage of the proceedings. The increase in principal was something the taxes had to be paid on.
Did you say 20109?
201.09 sub 1, the second of the last sentence there. I've since litigated this issue many times, and I'm confident now that it's the second of the last sentence of sub 1 in 201.09 that required the taxes be paid on the increase in principal, and they didn't do it. The key is the term renewal note. This is a renewal under 201.08 sub 5. So it's a renewal under 201.08 sub 5, and they had to pay the taxes on the increase under 201.09 sub 1.
Was 201.09 argued? I know 201.08 was argued
It
in the
was.
briefing.
I argued 201.08 more extensively because that's the statute which defines the term renewal, so there was a lot of argument about that. And then my opponent sort of argued at length about whether it's actually a renewal or not. It clearly is a renewal based on the increase in principal, and then the interplay of the two statutes together clearly shows the taxes had to be paid and were not, and it clearly didn't have to be split.
Which section are you referring to in 09?
In 09 sub 1, the second of the last sentence, a renewal note evidencing a term obligation which increases the unpaid balance of the original contract and obligation, but which otherwise meets the exemption criteria of this section is taxable only on the face amount of the increase. That is the sentence along with 201.08 sub 5, which required taxes to be paid on the modification, at least on the increased principal amount, and they didn't do it. So with that, I'll save the rest for rebuttal. Thank you.
Thank you. You'll have 2.5 minutes.
May it please the Court, I'm Hope Keating on behalf of Wells Fargo.
Hope Keating, thank you.
The default letter was properly entered into evidence, and there's sufficient competent evidence that it was mailed. It's established law that when, as here, a lender's employee who is extensively trained in record-keeping policies and procedures for generating and sending the default notice, testifies to the regular business practice of the lender in creating the default letter, printing and mailing it out to the borrower, and then once mailed, the letter's uploaded into its imaging system. It's cross-referenced against what was sent to be mailed, and where the collection notes verify the mailing as first-class mail, that's sufficient to authenticate the default letter as a business record. It's also enough to create the presumption that the breach letter was indeed mailed, and that's exactly what was done here. The witness had training on bank-wide procedures for record-keeping and the record-keeping system, and she did cross-training in various departments, including the letter-writing department. Although there's no evidence in the record, the Werners assert that a third-party vendor may have sent out the letter. But where a third-party vendor is involved, the witness only need testify how the vendor fits into the practice and procedures, the lender's practices and procedures for generating and sending the default notice. And the witness does not have to be familiar with the vendor's corporate structure or the vendor's policies and procedures, only how they fit into the lender's policies and procedures. And I would refer the court to the Balkison case, which is cited in the appellant's brief, and also the Pierre case, which we provided the court as supplemental authority. And here the witness testified that she had knowledge as to the process that a third-party vendor uses in the generation of letters, and that third-party vendors follow the same quality control procedures and processes as Wells Fargo does in-house. As for the documentary stamp issue, there's no evidence in the record that additional doc stamps are owed by Wells Fargo because of the modification agreement. It's undisputed that taxes were paid on the original mortgage, which was in the amount of $290,300. First of all, I would suggest to the court that that was an issue that should have been raised as an affirmative defense, or if deemed a condition precedent, it should have been denied specifically and with particularity as the rules of civil procedure require. Parties are required by the rules to let the other party in the court know what their position is, and rather than play a game of gotcha after a party has put on their case in raising an issue. Section 20108 mandates that additional taxes be paid on future advances. And here there were no future advances made
But
pursuant
if
to...
under 20109, if the debt is increased by something other than accumulated interest, would taxes be required, documentary stamp taxes on the additional amount?
Well, first of all, Your Honor, what is a renewal of a note? It requires analysis of 20108 and 20109 and the rules, the administrative rules under that. And
You didn't argue any administrative rules on the appeal, did you?
I don't believe they were mentioned in the brief, but it requires an analysis of the law.
It's your burden to, if there's some authority you want us to consider, but as far
Right.
as 20108 and 09, my understanding is you don't necessarily dispute that this is a renewal note. I think you've made some argument that it doesn't really change the original indebtedness because they were, it was interest and other costs and not really additional lending. But
Right.
the bottom line, I thought, of your position was that under 20108, the bar on litigation applies to a failure to pay documentary stamps on the original debt or on future advances, and that even if this were a renewal note, the bar would not apply. There'd be other remedies available to the borrower.
Well-
One question.
Well, first of all, with the law states that 20108 or 20109, one of the other states that there's not, when a modification doesn't enlarge the original contract or unpaid obligation, there are no taxes due on it. And consolidation of indebtedness is not a renewal under the statute that requires taxes.
The original indebtedness, is there any dispute that the original indebtedness has been increased?
It's been increased only because of Wells Fargo incurred and paid taxes and insurance and expenses while the borrower was in default.
20109 doesn't talk about things like attorney's fees and other expenses. It only talks about no documentary stamp taxes due if the increase is attributable to accumulated interest.
You're saying it doesn't say that, but I'm just saying that
I need some clarification on that. You're saying that it can be a renewal note and no problems, no requirement to pay doc stamps if it includes all sorts of expenses but not additional lending. But the statute seems to say it is part of the original, the note evidences part or all of the original indebtedness, evidence thereby, not including any accumulated interest. So it seems to me that it would be a renewal for which doc stamps are not required if the only reason for the change in principle is accumulated interest, not some other expenses.
Well, again, Your Honor, I believe it could also be interpreted to mean that a consolidation of indebtedness does not require, is not a renewal that requires taxes to be paid on it, and here that's what happened. The taxes and insurance that Wells Fargo paid were simply added to the loan amount that was already owed.
It refers to renew and extend only the unpaid balance of the original contract and obligation. So if there were, for example, a consolidation of two loans resulting in a note that is double the amount of the original note for one of the loans, would doc stamps not be required?
Again, Your Honor, I think this is an issue, and this is why it should have been raised as an affirmative defense, I believe, and all these issues they should have been tried. But let me just say this, regardless of whether it's a renewal or not, I don't think the court even has to reach that issue here to uphold the final judgment, because the language of 20108, as well as the 11th Circuit's opinion in the Wayne decision and the 4th DCA's opinion in the Glenn Wright decision, the only prohibition in 20108 on a court's enforcement of instruments pertains to failure to pay taxes on future advances. And this was not a future advance.
In your view, whether it's a renewal note or not, absent some showing that additional funds were lent as future advances, the statute barring the litigation does not apply.
That's what the court said in Glenn Wright, and also I believe that's what the 11th Circuit said. And I also point out that there's no case, even where a court has found that there is a valid future advance, where a court has found that taxes where taxes have been paid on the original amount lent, that failure to pay taxes on an additional amount pursuant to a modification agreement renders the entire loan amount unenforceable. And the court in the Nakui case, that was the 4th DCA, that's what they found. When the mortgage amount there, one of the mortgages was in the amount of $1,100,000, and taxes had been paid on it. But the court found that there had been a future advance made of $189,000. But the court didn't find that the entire mortgage lien was unenforceable, but rather the lien on the incremental amount, and remanded the case back for the lender to either prove that they had paid the taxes on the incremental amount, or to give them an opportunity to cure that. I just want to touch briefly also on the other issue that was in the brief regarding the admissibility of the loan modification agreement. The agreement was properly admitted pursuant to 90.902. Pursuant to that statute, extrinsic evidence of authenticity is not required for the admissibility of a list of certain types of documents, including business records, qualifying under 90.8036, that are accompanied by the declaration of a qualified person. And here, Wells Fargo witness testified and declared that the loan modification agreement meets those necessary requirements. One other thing regarding the documentary stamp tax issue, just point out that the purpose of that statute is for Florida, for revenue for Florida, and it's not to allow a borrower a windfall when they default. And there's no, don't believe there's any court, including the Soma court, that stated that a case should be dismissed because of the non-payment of documentary stamp taxes. Even in the Soma court, the court stated that upon remand, the court could, upon proper motion, abate the action for a time sufficient to enable the plaintiff to purchase documentary stamps. If there are no further questions, I would ask the court to affirm the final judgment.
Very good, thank you. Mr. Stope.
Thank you, Your Honor. Counsel notes the purpose of paying documentary stamp taxes. That purpose is not being fulfilled because lenders do this on a regular basis. They don't pay the documentary stamp taxes that are required by law, and the state is getting cheated out of their taxes systemically. That is why the Florida law, including in the Soma decision, contemplates dismissal where the taxes haven't been paid. I think that that's necessary here in order to show the lenders you can't systemically get away with not paying taxes.
There are other remedies, though, including criminal sanctions, correct?
I do believe there are other remedies, but I think...
And the statute that, the 20108 statute does reference basically a bar on litigating for future advances. And of course, on the other side, you've got the other statute, 199, that deals with the original loan and failure to pay dock stamps.
Here's, I think, the fundamental problem from a big picture perspective. Without paying the taxes on the modification is not enforceable. That's clear. And under the Radigan decision, when you have a modification of the loan, including an increase in principal, there's no way for them to foreclose. That's why I relied upon Radigan in the brief for that proposition. When the modifications...
The words of the statute are, and I'll paraphrase it, the mortgage as to any such advance, or the mortgage shall not be enforceable in any court of the state as to any such advance. And advances and future advances are defined elsewhere.
Sure, and so once you accept that the modification is not enforceable as to those advances, then they don't have a modification that they can travel upon, and then Radigan says that the remedy is to dismiss when they don't have a modification, because the terms of the loan were modified, but they can't enforce that agreement, so the only remedy then is, well, there has to be dismissal, because their whole payment history is predicated upon a breach of the modification, not a breach of the original note, but the modification is not even enforceable. So I submit that to fulfill the purpose of the statute, which is to ensure the taxes are being paid in these cases, we need a decision that says you can't systemically get away with not paying these, and following Radigan, the remedy should be an involuntary dismissal. And this issue is clearly not an avoidance. It's not something I have to prove. It's not an affirmative defense. It's an issue of enforcement where the modification is not enforceable, where the taxes have not been paid.
Very good. That brings us to the end of the time. Thank you.
Thank you.
Thank you, counsel. The next case is Turner versus Polk County School Board.